Are you concerned about whether a judge will consider the fact that your ex is bringing all kinds of bad people around your child and you would rather them not be exposed to such persons? Well, my name is Patrick Slaughter. I'm with LaFevor and Slaughter. And the simple answer to that question is yes. In fact, a judge has to. Tennessee Code Annotated Section 36-6-106 lists a number of best interest factors that a judge has to consider when making a custody determination. And one of those factors, Factor 12, says the character and behavior of any person who resides in or frequents the home of the parent and the person's interactions with the child. So if there is a person who is, say, a known drug dealer who happens to come about the home frequently, a judge is going to look down on that. If there is a person who potentially engages in other questionable or risky behavior, a judge is going to look at that with some caution, especially if that person has a criminal record or routinely engages in activities that cause them to be arrested or something along those lines. Now, again, a judge isn't going to like it, but the judge is going to look to see whether there's a connection between what this person typically does and how it could affect the child. If, for instance, when the child is gone, father has someone over to his house that mother would believe is a person of loose moral character, a judge isn't going to be as concerned about that. However, if this person is at father's house while the child is in his care and custody, then yes, a judge is going to be very concerned. So I think you have to look at what is it about this person that is questionable or is concerning. And what evidence do we have of that? Not just that, Sally's told Joe or whatever. If there's a criminal record, there should be, an NCIC printout or other kinds of public records that will demonstrate what those convictions may or may not be. If there are other activities, you need to be able to document those things, not just take the stand and say, Your Honor, I say. While your testimony has weight, how much weight it has can be diminished through thorough cross-examination, but it's really hard to cross-examine a piece of paper. If you have a public document that proves the person to have engaged in questionable behavior, it's really hard to cross-examine that document. So if you find yourself in a situation where your child is going to their other parents for during their custody time and the child is being exposed to people that concern you, you must identify what it is about these people that is concerning. You must try to find evidence to substantiate that concern, and then you have to be prepared to demonstrate that to the court in such a way that the court will mirror that concern. That's not an easy task, and most of the time you're going to need a skilled family lawyer to do that. If it's the situation that you're encountering, you'd like some help, feel free to pick up the phone, give us a call. We're happy to talk with you about it, give our honest opinion, and give you some options. But regardless, you need to come up with a plan, because if you don't, the judge may ask you some questions you're not prepared for, or the judge may discount what you're saying because you weren't prepared to demonstrate the severity of your concern prior to going to trial. So take the time, get the evidence you need, be prepared to explain your concern, and you should do well.